Good afternoon. I'm David Gans, the Civil Rights Director at the Constitutional Accountability Center. This morning, the Supreme Court heard argument in Brnovich versus Democratic National Committee, an incredibly important case about whether the Voting Rights Act limits voter suppression by the states. I listened to the 2-hour argument this morning, and what I heard suggests that the Supreme Court is poised to issue a major ruling that could seriously cut back on the protection of the Voting Rights Act. In 2013, in the 5-4 ruling in Shelby County versus Holder, the Supreme Court gutted the Voting Rights Act and transformed our multiracial democracy. Now, in Brnovich, against the backdrop of a rollback of voter suppression laws sweeping through state legislatures, the Supreme Court is considering whether to gut what is left of the Voting Rights Act. And that is the Act's nationwide prohibition on voting laws and practice that result in the denial of equal political opportunity. That's called the results test. It's an incredibly important part of the Voting Rights Act. And the reason why is it limits discriminatory results. It goes well beyond prohibiting discriminatory intent. This is kind of one of the most important parts of the Act. And it's all that's really left after Shelby County. At issue in today's case in Brnovich were 2 Arizona laws that sought to limit the right to vote. One that required rejecting any vote cast in the wrong polling location, and the other that criminalized third-party ballot collection efforts, as the attorneys argue today, that prevented even neighbors helping neighbors to make sure votes were properly cast and counted. But the biggest issue in this case is not the specifics of these 2 Arizona regulations, but what the court has to say about how the Results Act applies to laws that suppress the right to vote. There's a long jurisprudence about vote dilution and redistricting, but there's no jurisprudence at all about vote denial and laws that disproportionately disenfranchise voters of color. And the big issue before the court was, what would the standard be adopted? Would it give a strong protection against voter suppression by the states, or would they open the door even further to voter suppression of the kind that we're seeing working their way through state legislatures right now? And in the case, Arizona's Attorney General, who argued the case, Mark Brnovich, along with Michael Carvin, who represented the Republican National Committee, urged the court to really radically pare down the scope of the Voting Rights Act. They had argued that the Voting Rights Act is constitutionally dubious because it goes beyond prohibiting discriminatory intent and should be radically pared down. That argument, as CAC argued in the amicus brief it's filed, is completely out of line with the text and history of the 15th Amendment. The 15th Amendment importantly gave Congress a sweeping power to protect the right to vote, to stamp out any kind of measure that stood in the way of voting rights, and essentially to ensure that the right to vote was in fact on the ground equally enjoyed by all, regardless of race. Now, the constitutional attack on the results test didn't get much action. I think it was mentioned once by Brnovich, but I think what you saw, and this is something that's critical, you saw a lot of the conservative justice looking for other ways to pare down the scope of the act. They didn't press the argument that there was a constitutional flaw in the results test, but they were looking for ways to cut it down. So one thing you saw Justice Samuel Alito and Justice Amy Coney Barnett mentioned was you had to have some limit, otherwise all measure of state voting laws would be subject to challenge, because anyone could say this has a discriminatory impact and therefore it has to be thrown out. But if you look in practice, the lower courts have applied the law in many situations, and the laws that have been struck down under the results test are arbitrary discriminatory restrictions that can't be justified by the government. So the idea that this would end state voting regulation really has no basis in reality. So second, you saw arguments from Justice Brett Kavanaugh, who said, well, this isn't actually pure results test. The statute was a compromise, and so we can't really take it. We can't really take the results test language and apply it in a broad way. But the problem with that is, we look at the statute's text. The statute's text says, it's unlawful for a state to enforce a law or policy that has the result of denying equal opportunity to voters of color. So he seemed to really be fighting what the text said. Lastly, we saw Justice Gorsuch saying, we should really have a heightened causation standard. There was some mention of last term's landmark Title VII ruling where Justice Gorsuch rejected that standard, but he said, well, that was Title VII. This is the Voting Rights Act. And he seemed to pick up a suggestion made by the Trump administration that there should be a heightened standard put in place in the Voting Rights Act. And that really gets us to, really an important facet of the argument. Sort of often we talk about sort of what was said, but just as important in this argument was what wasn't said. The Biden administration filed a letter with the court that disagreed with the Trump's position in this case, but they failed to explain why it was wrong. And the silence really loomed large over today's argument. The justice had asked numerous questions about the Trump administration brief, and there was no one who had said, no one on the Biden administration's behalf who had said, this is why it's wrong, and particularly against the backdrop of a rollback of voting rights that we're seeing going on right now, the fact that the Biden administration didn't make clear why the statute needed to be given a broad construction to ensure protection for the Voting Rights Act really loomed large and was felt during the oral argument. So I think this is going to be a very important case, and I appreciate you tuning in. For more in the case and to read our brief, please go to www.theusconstitution.org. Thank you so much.